Hello, this is Bob Ricco, and I'm here to talk a little bit about the law. Today's topic is a different area. It's going to be what happens in the state of New Jersey if you have a situation in which you have a husband and wife living together, but for whatever reason, the house is only in one party's name. Maybe that house was there from a prior marriage. Maybe it was there just because one of the spouses owned it before they got married. Um, Now, sometimes those kind of issues, whose house is it, can be determined in a divorce. And that's because someone will ask for equitable distribution. But what if it's a happily married couple? There is no issue about divorce, and nobody ever thinks about going down that path and getting the judge to say who owned what. Instead, what you have is a happily married couple, but the house nevertheless is in only one of their names. Well, until 1980 in New Jersey, if one spouse died, meaning this, especially the spouse that owned the home, the other spouse got the rights from some ancient medieval type thing called dower and curtsy, and they had the right to have a life estate and live there for the duration of their life. Assuming, of course, that the house was paid for, or they could be paying the mortgage if there was one, etc. I'm not talking about the bank issues. But they passed a different law, a statute that abolished that. And so now the situation is you could end up with just the right to live there as a spousal marital residence until the owner spouse dies. So that could mean that you could find yourself as a surviving spouse in a house that you don't own. And what if that decedent spouse left her home to someone else?